Hello and welcome. My name is Eric Eisenman. I am a partner in Husch Blackwell's Milwaukee office, and I currently serve as the chair of our National Labor Employment Practice Group. It is also my honor to co-lead our firm's workplace diversity, equity, and inclusion sub-practice. You'll hear from a number of our team members today. Before we get to our content, I have just a few housekeeping items to cover. At the bottom of your audience console, there are a couple application items that I'll tell you about that you'll be able to use during the program today. If you have any questions during the webcast, you can submit those via the question box that you have there on your screen. Those will pop up on our end and we'll be able to see that. We may have an opportunity to answer some of those questions during the presentation today, either electronically or if you catch us at the right time during our verbal presentation. But if we run out of time and there's still questions in there, we'll be sure to follow up with you after the presentation's concluded. A PDF copy of this presentation is available in the program materials folder that's there on your console. This program has been approved for legal education and HR, continuing education hours. For live attendees, you'll be able to report your attendance with the CEU icon that's at that bottom of the screen. You'll get a certificate of attendance with the course numbers that'll be emailed to you tomorrow, along with a recorded copy of our webcast for you to watch and to share internally with others at your organization if you like. Towards the end of our presentation, we're going to ask for you to complete a short survey that helps us plan future programs and make sure that we're touching on the content that's most useful and valuable for you. That's it for housekeeping. So we're going to get started with our program. As all of you know, interest in developing and implementing diversity, equity, and inclusion programs in the workplace has increased dramatically over the last couple of years. From our perspective, this has been an extremely positive development as DE&I initiatives are proven to improve employee recruitment, retention, morale, and to help mitigate risks associated with disparate treatment or employment discrimination claims. That said, it would be fair to say that we were kind of at an inflection point right now. Across the country, we're beginning to see an increasing amount of pushback against these concepts in education, in the workplace, and in other places in the public sphere. Just this week, you may have seen an article in the Washington Post about Governor Ron DeSantis signing a bill in Florida intended to defund DEI programs at Florida's public colleges. Or the article in the New York Times about some companies pivoting from the concept of diversity and inclusion into diversity and belonging in the face of some of this pushback. For all of those reasons, I think our conversation today is a timely one. Our goal today is to help give you an understanding about the current state of the law in this space, what you can expect moving forward, and our observations and recommendations based on the conversations we've been having with our clients. We have a lot of ground to cover in an hour, but I hope you'll find the following presentations helpful and informative. I'll let each of our presenters quickly introduce themselves at the beginning of their sessions, but I'll do an overview here. I am very pleased today to be joined by my Husch Blackwell colleagues, Sarah George, Mike Matta, Tyler Patekow, Taronda Randall, Elizabeth Samples, and Betsaida Zudi. My fellow workplace DE&I team co-leader, Katarina Cologne, was also scheduled to be with us today, but was called away to attend to a family medical issue. We send her and her family our best wishes. Finally, we're also lucky to be joined by David Marsden Pearson, principal consultant at the international law firm Pinsent Masons, who will be providing a unique perspective about these issues as they are playing out in countries outside the United States. With that, Mike and I will begin by talking about some of the legislative and political pushback against workplace DE&I, and provide some advice about how to continue to invest in this area without exposing your company to unnecessary legal risks. So before I jump in, Mike, maybe I'll let you just give a brief introduction to the group. Tell us a little bit about you and where you're officing.
Yeah, thanks very much, Eric. My name is Mike Matta. I am an associate here in the Los Angeles office, practicing labor and employment law. I help employers on a day-to-day basis, guiding them on, day-to-day employment issues, guiding them through terminations, workplace investigations, things like that. And then when, things go south, I help them out in litigation as well.
And Mike has been a great partner for me on this topic. He and I, along with one of our colleagues, Melissa Williams, in our Madison office, co-wrote a piece on this concept of DE&I pushback. But we thought it would be a useful topic to talk about during this presentation as well. So when we talk about pushback, as I mentioned, you'd almost have to be blind not to sort of see this topic coming up in the news. We've got highlighted here on this slide, perhaps the most sort of prominent example, the Stop Woke Act, Stop Wrongs to Our Kids and Employees Act, which was passed in the state of Florida and signed into law last year in 2022. That law, as it was drafted, prohibited employers with 15 or more employees from requiring those employees to attend training or programming that espouses various beliefs. There's a category of various different things that are prohibited under that act, but in general terms, it would prohibit the sort of training or teaching that an individual is inherently racist, sexist, or oppressive, or that an individual should experience any kind of discrimination because of actions committed in the past. As drafted, that law empowered the Florida Commission on Human Relations to pursue either an administrative or a civil action, including remedies like injunctive relief, compensatory, and punitive damages. Now, a component of this law was actually enjoined at the end of the year last year by a judge in Florida. But these provisions that apply to employers are still technically in effect. We have not yet seen exactly how the enforcement mechanism is going to play out. But suffice to say that this has caused sort of significant consternation among employers in Florida who have been implementing these programs. What we'll talk about in a few slides here will be sort of our advice and recommendations if you're a Florida employer or somebody in another jurisdiction where this is being considered, about what exactly these laws say and do and how you can still continue to invest in this area, notwithstanding the application of these laws. But that's sort of example one. Mike, why don't you talk about that other example that you and I discussed in Florida, and then maybe talk a bit about what's going on in some other states?
Yeah, absolutely. This was a bill that was just passed in Florida, SB 1718. This would require both private employers with 25 or more employees, as well as public employers, to use E-Verify to verify employment eligibility starting in just a few weeks, July 1st, 2023. And employers would have a 30-day period to cure any non-compliance. And this carries some severe consequences. Those that fail to use E-Verify 3 times in a 24-month period would be fined $1,000 per day until the employer provides evidence that it's cured the non-compliance. This also carries some unanticipated consequences that Eric and I discussed as well. You may have seen headlines about this, but there's a serious shortage in production in Florida right now. There are grocery stores that have empty shelves. So clearly this is having some consequences that the legislature in Florida may not have thought about as they were drafting and pushing towards this law. And, we see other states as well. This is happening in quite a few states, including Texas. 2 notable examples that we wanted to discuss. And these bills haven't passed yet, but Texas House Bill 1006 would amend the Texas Education Code and would prohibit diversity-related initiatives in higher education, quote, beyond what are necessary to uphold the equal protection of the laws under the 14th Amendment. And this bill also requires that higher education DEIA policies must, quote, demonstrate a commitment to intellectual freedom and viewpoint diversity. So you can see that this isn't as much creating actionable parts of law as it is signaling potentially a value that the Texas legislature has, or at least most of the Texas legislature may have. And in the alternative, though, we see other bills that have more severe consequences in Texas. Texas Senate Bill 17 would prohibit public higher education institutions from DEIA offices altogether, or requiring DEI statements at admission or hiring, and then again carrying those penalties with respect to first-time violators, preventing a university from hiring them, and then any repeat violators could be terminated and not eligible for rehire. And again, one of the consequences that Eric and I discussed is whether this is going to impact a university's ability to hire and retain professors, faculty, staff, et cetera. This is a little bit of uncharted territory, so we don't know exactly how this is going to impact other parts of the workforce, but it certainly will.
That's right. That's right. And so what we thought might be helpful here is to do a little benchmarking that could be useful for the participants. We're going to do our first two poll questions here. The first question is going to be, has your company increased its investment in workplace DE&I initiatives in the last 3 years? I'll ask you to go ahead and click one of those answers: increased, no increased, or my company doesn't currently have a DE&I program. I can see here that some folks are entering that data. I'll give you a minute to do that, and then I'll click through and we'll be able to see some of the live results. Mike was talking about those Texas bills. That was sort of an analogous Florida bill that I talked about at the beginning that Governor DeSantis signed into law yesterday. And as Mike said, we don't really know what the consequences of this are going to be, but we've already seen some initial reaction from professors at universities in Florida who are talking about whether they feel like they can effectively teach their curriculum under those sort of strictures. I think it's also relevant to note that those sorts of laws are going to be challenged under the First Amendment. There's an argument that is state-based sort of content discrimination. So let's see what we've got. Yes, it looks, and this doesn't surprise me, more than 70% of our attendees here have increased their investment in workplace DE&I over the last 3 years. That's consistent with sort of what we've seen. Here's maybe the more interesting question relevant to the presentation that Mike and I are talking about now. Within the last 6 months, kind of in this window where we were looking at the Stop Woke Act and other laws like it, has your company altered or scaled back its DEI programs in response to either internal or external feedback or pressure? I can tell you anecdotally, I certainly have had conversations with some of my clients about, hey, is there something that we should be doing differently? Are there components of our training that we need to modify? Are there things that we need to be mindful of so we're not putting an unnecessary target on our back? It'll be interesting to see whether that is actually occurring sort of across the country. I think in states like Florida or Texas, where you're seeing a little bit more of this legislative activity, that's probably likely. Even in Wisconsin, where I'm coming to you from, we're a pretty purple 50-50 state, history of sort of progressive politics. The board of trustees here in the State University of Wisconsin has removed DE&I statements from job applications for applicants for the university. So not as far as what some of the other states have gone, but we're seeing that in other jurisdictions. So it looks like a small number of our attendees here, about 10%, have made changes or scaled back. 90% have maintained. I think that makes sense. It will be interesting to see sort of how those numbers trend. So, when we talk about, how you as an organization respond to these sort of things that are going on, there's a couple of things that we can tell you. The first and most important thing is to carefully review and understand what the laws actually say. If you go back and you look at the Stop Woke Act, the language there, essentially what it's prohibiting are mandatory trainings. So voluntary trainings are not prohibited at all. It's mandatory trainings where you might require an employee to be there. And second, it's prohibiting the sort of concepts where they're going to be, targeting an individual, suggesting that individual bears guilt because of the actions of his or her, class in the history. There's sort of extreme things that are unlikely to occur in the normal sort of DE&I training that we are observing from our clients. So the vast majority of the sort of things that our clients are currently doing in this space are not going to run afoul of these laws. If you're developing a plan, and Mike will talk in a minute about some recommendations there, you can do so in a way that articulates the reasons for why we believe it's important, not singling out an individual or a group of individuals as responsible or guilty. Tailoring those communications that creates space for all participants to communicate and understand and share their perspectives, again, so it doesn't make any particular group or class feel singled out. And to utilize trained folks who have experience in this area to be conducting the trainings. So Mike, do you want to talk a little bit more about what you sort of have seen as key components of that strategy?
Yeah, absolutely. The first one that I wanted to discuss is having initial buy-in from the top down, from company leaders. This is a really important way in which a company can genuinely express to its workforce that it truly understands the importance of DEIA initiatives. And frankly, it's much harder to express to employees that a company is truly taking actionable and meaningful steps towards DEIA when the messaging isn't coming from leadership. Next, having a DEIA team. Developing a DEIA strategy involves a lot of nuance, a lot of expertise, and having a team, a dedicated team, better ensures that a company can reach its goals and can have goals that are both measured and calculated and then actually realized. Next, using data, having data analysis and transparency. The only way, one of the most important factors, at least for a successful DEIA strategy, would be if it incorporates whether a company is honest with itself about its practices and its efforts and the way those efforts are reflected in the workforce, to then understand gaps, inform opportunities, et cetera. But on the same token, using data and not using data in important ways is something to consider. Be sure not to use data to make any employment decisions. So one rule of thumb that I like to tell employers is don't let the data you have guide a decision to, for example, hire someone, but instead let it guide how the company can improve its efforts on outreach to truly create equitable employment opportunities. Next, having a communications toolkit. Here, we often hear buzzwords like diversity, equity, inclusion, accessibility, et cetera. When you're relying on these words and phrases, being able to expand on them in a meaningful way helps convey the importance of those values to employees, but also helps clarify why they're important to us. And of course, you want to get the green light from legal when developing the strategy in the first place. And finally, and I know Eric mentioned this already, but we really want to hammer this point home. Conducting DEIA trainings is incredibly important. You may have a new workforce, including new leadership who may need to be trained. There are, of course, social concepts that grow and may need to be understood and explained in the workplace. And again, this key component is incredibly important for an effective strategy.
And that's the big takeaway, I think, when we think about pushback and how we respond. There is nothing in any of these laws that we've discussed or that we've been tracking that's going to prohibit an employer from continuing to invest and train in this space. There are some things to avoid. Think about, voluntary rather than mandatory trainings. Think about the way you're structuring it. But the big takeaway we want to have is that there's nothing from a legal perspective we see that is going to prevent companies from investing in this area that, as I said, our data suggests has been very effective. So let's pivot from what's going on in the United States and bring in our international expert. I'm going to ask David Marsden Pearson to join us. Thanks, David. And David wins extra credit points because he's joining us in transit here. But David, why don't you introduce yourself to the group? Tell us a little bit about yourself, and then talk to us about what's been going on in other jurisdictions.
Great. Thank you very much. Lovely to meet you all. Lovely to be with you. So I work at Brooke Graham, which is part of an international law firm called Pinsent Masons. We operate in all jurisdictions around the world. In the US, we use our friend firms to operate there. I'm going to share very briefly some reflections about what's going on internationally. This is by no choice of mine. It's going to be reasonably high level. What I thought I'd do is break down some of the emerging trends for you into three buckets to make it a bit easier to maybe get your head around what those are. So I've put them into these buckets of what I'm calling mainly external factors or trends, mainly internal, and mainly and ones that are a combination. And I've just realized that because I've got animations, it'll help if you actually see the big reveal. So let's just go back to that. Oh, okay, interesting. The slides are doing something very unusual at the moment. Okay, so in terms of, and this is kind of a UK view, but it also encompasses Europe, Australasia, to some degree Canada, but obviously the world's a big place. So the trends that are showing up in any one jurisdiction will vary a lot. But if you think about these external drivers, Black Lives Matter, that movement had a huge impact, not just in the US, but worldwide. And it put the wind behind the sails of change around diversity and inclusion. And when I'm going to use the word D&I, or diversity and inclusion, because the longer version takes longer to say. But that was a really important moment to get a lot of wind in the sails. However, what we're noticing is that to some degree, that's now coming up for renewal. And we're wondering a little bit what that next trend is going to be, that next socio-political driver. Now, somewhat worryingly, it's possible that next trend is actually going to be a negative one. And, we've already just heard then about some of the backlash. And we're seeing a bit of an anti-woke backlash in parts of the UK, parts of Europe. And we're wondering, will that crystallize into a movement against diversity and inclusion generally? You might say to me, well, David, what does that look like? Well, one really concrete example, unconscious bias training. In other words, training in organizations that raises people's awareness of the existence of bias. The UK government is very skeptical about that training, and some organizations are as well. And they've sort of put out a lot of narrative around how unconscious bias training doesn't work, etc., etc. Regulators are always active in this area, and they're looking particularly at culture and how behavior within organizations can be regulated, not just tick box compliance. Shareholders are often quite active in demanding to see progress around diversity and inclusion. And tied to that is the rise of the ESG agenda, so environment, social and governance issues. In the UK, social values are a very strong theme. It may not be that familiar to many of you, but basically it's a question that says, it's great that you're coming in to do work in our community, but what lasting change are you going to make as an organisation? What value will you add to society? And that could take all sorts of forms. And then the role of procurement and how you procure suppliers who are diverse is another area. So that's kind of the external landscape. If we look at the mixed ones, we're not really meant to use this word war for talent anymore. It's the striving for talent, or the seeking after talent. But it's always difficult to find skilled people. And what we're trying to do with diversity and inclusion is unlock some of the amazing diverse talent from underrepresented groups so that they have a chance to take part and contribute in the workforce. COVID, do you remember that? It seems like a distant memory for some of us, I think, but there's also this idea of the great retirement of people finding out that through lockdown and COVID, did they really need to work 40 hours a week, 80 hours a week, 5 days a week? Perhaps not, and many people are either going down to part-time work or taking career breaks. That has an impact on inclusion, as does the idea of a two-tier workforce, where some people get to work at home or remotely, and other people are expected to work on site in the office. And that can also set up some questions around equity, equality, and inclusion. Here's a really interesting one that we're very excited about: virtual reality. I don't have time to poll you now on this, but I wonder how many of you have had any exposure to the use of virtual reality to support diversity and inclusion progress. We're excited that we use it here. It's very good at tapping into empathy. And then there's the changing definition of employee. People who work part-time, people who work on a 0 hours contract, people who are gig economy workers, people who are not employees but contractors. Where do they fit into the mix, and how do they get looked after through DEIA? And then the last lot is the mostly internal ones. Broader definition of diversity. I mean, sometimes we're used to talking about race and ethnicity, gender, disability, sexual orientation, but what about all the other aspects? Positive action. I know in the US there is a specific definition for that, positive discrimination. In other parts of the world there are different definitions, but guiding organizations on what they're allowed to do legally and where they start to cross the line into things that discriminate against the majority. That's an important area we advise on, and we advise with our colleagues on the legal as well as the cultural and practical aspects. Employee attitudes to D&I. In the old days, you could leave, employers would just leave you to get on with things and check in once a year to see how you were going. Now they're checking in real time. Are you making progress like you promised as an organization? Measuring before I close, so I'll leave that one. Leadership, yeah. What's the role of leaders in being accountable for D&I rather than just making nice statements? So in my last 60 seconds, I want to tell you about one of the things that we're working on that's very exciting. I've got a number of clients I'm advising right now on this question of how do you measure inclusion? Because many of us are used to measuring diversity, and that's often about headcount and representation. But how do you know whether your organization is truly inclusive? So we have 5 dimensions that we measure on to find out how inclusive your organization is. And we're finding that's really helpful for organizations. Tiny bit about us, just to reiterate that we are global, that we provide practical advice from businesses to businesses, and we have a tailored approach to everything we do. All of our solutions are bespoke. We don't just sell off-the-shelf stuff. And just to give you a little bit of an idea of some of the sectors and clients we cover, there are lots of global names that we work with as well as regional ones. So what I'm going to do is leave you in the capable hands of my colleagues here, but I've got some two-poll questions. One of them is a ranking question asking you to put in order which of the terms are the highest priority for organizations. So when you go into Menti, you'll see that. And then there's one other question saying what other topics are on your list. And I'll leave my colleagues to let you work out how to basically point your phone camera at green, follow the QR code. It's been wonderful to join you. And I really look forward to you having a fantastic rest of this session.
Thank you so much, David. We really appreciate you joining us. Tell us quickly, before you drop off, where in the world are you right now?
Funnily enough, I'm literally sitting in the Royal Opera House in Covent Garden in the middle of London, in transit.
That's great. That's great. Well, thank you for making the time. I'm really fascinated by the way that DE&I concepts in the United States have influenced those that are happening in other countries and vice versa. David mentioned the impact of the George Floyd murder. I think that's really interesting. And for those of us who have employees and operations outside of the United States, I think it's important to think about the impact of the decisions that we're making, not just here domestically, but internationally as well. What we're going to move to next, I'm going to welcome in my partner, Tyler Paetkow in California, to talk a little bit about the way in which DE&I and the National Labor Relations Act might interact. Tyler, why don't you introduce yourself to the group?
Hi, everyone. My name is Tyler Paetkow. I'm also a labor and employment lawyer. I've been practicing for 33 years in California, but who's counting? And it's great to join you. I don't have a British accent, but it is good to be on the right side of history. So welcome, and hopefully we can provide some good guidance here.
Thanks, Tyler. Why don't you tell us a bit about sort of what the NLRA is for those who are with us that may not have the background and info?
Sure. So the National Labor Relations Act has been around for a long, long time, many decades. And people think of it as a law that applies to unionized employees or employers, but it actually is broader than that. And what we're going to focus on, or one of the things we'll focus on, is Section 7 of the NLRA allows or protects employees' right to organize, to bargain over terms and conditions of employment. And some of you may have heard, even if you're not unionized workforce, a few years back, there were a number of cases before the board on overbroad social media policies that people would post on Facebook about, the coffee's too cold in the workplace, and then they would get likes on it, and all of a sudden it would be protected activity under Section 7, and that applies even if there's no union in the picture. So that's kind of the background here in the context. I should also mention that I'm here to say that there's a way to do this legally and enforceably, but there are some risks out there, just traps for the unwary. In addition to the traditional labor law risks that we're going to talk about, there's also potential anti-discrimination risk, Title VII, and tension between Section 7 and the prohibition on discrimination under Title VII and state law counterparts. And, we can't do a program without talking about the ubiquitous wage and hour risk, which may come up with the what we're going to talk about, employee resource groups, where the employees are volunteering for time served on the ERG, and at what point does it become compensable time? So that's a quick legal overview.
So why don't you set the table for us then? What is an employee resource group, for those of us who may not have those in our organization? So
the ERG, Employee Resource Group, is basically a network of employees formed around common interest. And they could be, the same backgrounds from underrepresented communities. I was reading just in preparation for this, there's some ERGs that are formed around age-protected workers, which is near and dear to my heart. I used to joke that nobody in my audience was in the protected age class, but now I'm in it. So there's a number of different ERG formed around these common interests, and that's what it is. The trick is, or the risk is, that the employer cannot dominate that group and turn it into a union, a labor union. We'll talk about this. Section 8 talks about wages, hours, and other terms and conditions of employment, and that is not the purpose of an ERG. It's employee sponsored and managed with input from management, but it's not a traditional labor union.
So before we jump into sort of how these two concepts fit together, let's do our last poll question here. Again, for benchmarking purposes for the group, attendees can say, does your company currently have employee resource groups or affinity groups? And while we're waiting and tabulating here, Tyler, maybe you want to talk about this idea of affinity groups. Are they the same as employee resource groups? Is there a distinction? Is there a preferred terminology here?
Yeah. So, I didn't realize this until I started boning up for this webinar, because I've heard both terms used interchangeably. And what I'm learning is that affinity groups is a word not to use, because it may connote some type of exclusion or some social purpose. Employee resource groups is a much better phrase for what we're talking about. It's a resource for employees. It's dominated by employees, not the employer. Whereas infinity, just the word, may convey the wrong message. We're about inclusivity, including who can participate in the employee resource group, and I'll get to in a minute some tips on that. But that is one suggestion, is to not use the word affinity group.
Looks like we have about 50% of our audience has either affinity groups or employee resource groups. As an anecdotal piece of data, Husch Blackwell, our firm, I know has a number of employee resource groups right now. HB Unidos is a group for our Latino employees. HB Black for our African American employees. There is an LGBTQ group. I know the firm right now is working on standing up an employee resource group for employees with disabilities. We have found them to be, I think, an effective tool and have received positive feedback from them. I'm a member of the HB Allies group myself. So Tyler, we understand a little bit what they are. How does this sort of intersect with the NLRA, and what am I worried about here?
Yeah, so just to add to what Eric was saying there, the trend is certainly towards offering ERGs to employees. One survey said recently 90% of Fortune 500 companies now offer ERGs. A number of middle market, smaller companies are starting to offer them as well. So from a labor law perspective, again, the NLRA, Section 8A2 of the Act makes it an unfair labor practice for an employer to dominate or interfere with the formation of a labor organization, of a union. And it also defines a labor union broadly as one that's formed for the purpose of discussing grievances, labor disputes, wages, rates of pay, hours of employment, conditions of work. So it's a broad definition. One of the concerns, which, although I think it's overplayed, at least in the media, is to what extent or when does an ERG become a labor organization? And we have some guidance, although with all of this that we're talking about today, the law is unsettled and evolving. So that's my lawyer disclaimer here. But currently we have an older case, Electromation, if I'm pronouncing that correctly, back in 1992. And in that case, the board considered the employer had formed a management employee group called a action committee. And the board, in that case, drew a line between groups whose formulation and structure are determined by employees versus those whose structure and function are essentially determined by management, and whose continued existence depends on the fiat of management. So that's some older guidance that we have from that 1992 decision.
I've heard that, and folks listening may have heard the phrase sweetheart union. I mean, that was the idea, right? Is that if an employer is experiencing an organizing campaign and decides to implement a committee, which essentially is going to serve the purpose of the union, but is going to be controlled or directed by the employer. That's what the board has historically held to be unlawful under the Act. And I think the question is, is there a scenario where an employee resource group, well-intentioned as it might be, crosses the line to be the sort of organization that the board in Electromation said was illegal?
That's correct, Eric. And one, not to get too far into the weeds here, but one risk is in a union organizing campaign. If the employer says, "Hey, we can address the employees' concerns. You don't need a union," and all of a sudden they rush out and say, "We have an ERG. We'll take care of the employees this way. You don't need a union." That's a real risky proposition for employers. In fact, there was a case just this year before the board involving T-Mobile. And T-Mobile created a T-Voice program that had a worker feedback to provide it to the employer. The problem, I think, the primary problem was that it was set up during the organizing campaign. In the middle of it. So the board, in that case, it was Communications Workers of America trying to organize T-Mobile's call centers across the country, and the board had no trouble finding that violated the act. That it dominated this organization and interfered with union representation, union organizing campaigns. So that's a real risk area. But on the positive side, if it's structured correctly, and you have a compliant ERG policy, and I have a checklist of things that we probably don't have time to get into today, there is a way to do it right. That's just a risk area during an union organizing campaign. It's a little more risky.
How about compensation or benefits for employees who are participating in these efforts? I saw one of our questions in the chat, which we don't have to answer now, was sort of what the trend has been in terms of paying folks who are providing leadership service on these ERGs. Do I have to bargain with the union if I'm going to do that?
So, these are voluntary programs and voluntary participation by employees. A lot of employers are making facilities and equipment and teams resources available for the ERGs, but beyond that, it's not compensation. So anytime you're going to be affecting, especially compensation, that's a key term and condition of employment. If there is a union in the picture, it's a good idea to involve them early, that we're creating an ERG. It's not to compete with the union, it's to provide a resource to our employees and to really get the union's buy-in on that before implementing it.
Excellent. Well, Tyler, thanks so much. I know we hit that pretty quickly. It's a great gift for us to have Tyler and his team in California with their experience both in that quirky state-specific laws, but also labor law issues that are frequently coming to our attention out there. So thanks for your time. I'm going to now turn it over to two of our members of our higher education group, Elizabeth Samples and Taronda Randall. I understand that Taronda is going to be leading off. So I'll let you introduce yourself, Taronda, and tell us a little bit about your topic here.
Thanks, Eric, and so good to be with everyone here today. My name is Taronda Randall. I'm Senior Counsel in the Kansas City office of Husch Blackwell, and I practice in the higher education group. So today, Elizabeth and I are going to talk a little bit about the impact of the Supreme Court decisions related to affirmative action. So to kick things off, we'll talk a little bit about Students for Fair Admissions versus Harvard, just some of the facts of the case. So Students for Fair Admissions, which is a nonprofit advocacy group that opposed affirmative action, brought an action against Harvard, alleging that they violated Title VI of the Civil Rights Act by implementing a race-conscious admissions program that SFFA contended discriminated against Asian American applicants. So in conjunction with this lawsuit, SFFA also brought a lawsuit against UNC, which I'll talk about a little bit later. And SFFA claimed that Harvard and UNC both ignored viable race-neutral alternatives for achieving a diverse student body. So let's talk about Harvard's admission program. Harvard uses a whole person review, which the admissions committee considers each applicant's unique background and experiences, alongside, of course, their academic achievements, to find applicants of exceptional ability and character who can help enrich the campus community. They want it enriched on multiple dimensions. So, of course, the academic interests, extracurricular, race, social economic background, and life experiences. Harvard also uses a system of tips, which the First Circuit kind of described as plus factors that just might tip an applicant into Harvard's admitted class. The admissions officers were able to award tips based on a range of factors. So things such as outstanding and unusual intellectual ability, unusually appealing personal qualities, outstanding capacity for leadership, creative ability, athletic ability, legacy status, as well as geographic, ethnic, or economic factors. And the personal ratings, of course, as you can imagine, were by far the most subjective area, and that's ultimately what the lawsuit boiled down to. And for example, the ratings were ranked as 1, outstanding, 2, very strong, 3, generally positive, 4, bland or somewhat negative or immature, 5, questionable personal qualities, 6, worrisome personal qualities. And Asian Americans received the lowest personal ratings score, but the highest when it came to academics and extracurricular. So SFFA versus UNC, as I kind of mentioned earlier, originally both of the cases were brought at the same time, and they were consolidated, but following the appointment of Justice Ketanji Brown Jackson, who's a member of the Harvard Board of Overseers, the cases were split, with Justice Jackson abstaining from the Harvard case while participating in the UNC case. So in the UNC case, petitioners for SFFA sued UNC over submission process, alleging that the process violated the 14th Amendment by using race as a factor in admissions. Now, UNC admitted that it uses race as one of the factors in the admissions process, but argues that the process adhered to the factors required under the Supreme Court decision in Grutter versus Bollinger. And UNC admissions program viewed every individual on an individual basis based on factors that they revealed in their application. And race was just one of those factors in a holistic review of all the circumstances relevant to the individual applicant. And a plus was awarded, and it may have been significant in an individual case and just might tip the balance toward the admissions of that particular individual. So some of the precedent at issue. So we have the Regents of the University of California versus Bakke. And so in that case, we had a 35-year-old white man, Alan Bakke, who had applied for admission twice to the University of California, Davis's medical school, and he was denied both times. On the ruling in the case, the court ordered his admission into UC Davis and validated UC Davis's special admission program and held that universities can consider race in their admissions process to a certain extent. Then we have the 2003 case, Grutter versus Bollinger. In 1997, Barbara Grutter, she applied for admission to the University of Michigan Law School, and she was denied. Grutter argued that there was no compelling interest to justify the use of race as a factor for admissions, and the university argued that they had a compelling interest in promoting diversity for educational benefits. The ruling in that case, colleges and universities can use a narrowly tailored race-conscious measures to promote diverse student bodies. Then we have our two Fisher cases. So in 2013, Abigail Fisher, a white female who was not in the top 10% of her high school class, applied for undergraduate admission to UT. 2008, but was denied. UT had a program where they admitted the individuals who were in the top 10% of her class. So the issue in that case was whether the Equal Protection Clause of the 14th Amendment permitted the consideration of race in undergraduate admissions decisions. And the ruling in that case came down to the Equal Protection Clause permitting the consideration of race, but only under a standard of strict judicial scrutiny. So then in 2016, a couple years later, a new question was presented, and that was whether UT's use of race as consideration in the admissions process violated the Equal Protection Clause of the 14th Amendment. And the outcome of that was that UT's use of race as a consideration in its admission process did not violate the Equal Protection Clause of the 14th Amendment. And with that, I'm going to pass it to Elizabeth to talk a little bit more about the issues at hand.
Thank you, Sharonda. My name is Elizabeth Samples. I'm a partner in Husch Blackwell's Higher Education Group, and I office in Kansas City. Happy to see many of our higher ed clients on the call today, as well as our non-higher ed clients. Taronda and I had a bit of a heavy lift today to talk about a really important topic with kind of significant constitutional and statutory precedent in a short amount of time, and talk about sort of its potential application in the employment realm. So again, we're covering this at a pretty high level, but want to kind of talk about ways that this might impact, various of you on the call. So just to quickly kind of highlight, as Taronda mentioned, want to make a distinction here about the statutory and constitutional claims at issue in both of these cases. And that becomes important when we consider the potential impact that this case may or may not have on, employment-based initiatives. So because Harvard is a private university, the Equal Protection Clause doesn't apply. So rather, the arguments that are being made are under Title VI, which is the federal law prohibiting recipients of federal financial assistance, both public and private, from discriminating on the basis of race, color, and national origin. And in prior precedent, the Supreme Court has held that Title VI imposes the same standard that the Equal Protection Clause imposes on state actors. So the question is whether Harvard's race-conscious admissions process violates Title VI. And Students for Fair Admissions asked the Supreme Court to hold that the practices did violate Title VI, that these race-based admissions practices that if done by a public university would violate the Equal Protection Clause. And so to sort of quote, from the case, they're arguing that Title VI is being violated by penalizing Asian American applicants, engaging in racial balancing, overemphasizing race, and rejecting workable race neutral alternatives. The district court and the First Circuit were unpersuaded and ruled in favor of Harvard, finding that their race conscious program was narrowly tailored to a compelling interest. And as Taronda sort of walked through, those two slides about the particulars of Harvard and UNC's admissions practices, that type of evidence obviously becomes very important, right, when the institutions are trying to argue how their admissions practices are legally compliant, at least under existing precedent. And so then when we turn to UNC, as a public institution, Students for Fair Admissions made equal protection claims under the 14th Amendment, arguing that UNC was unfairly considering race in its admissions process, giving significant preference to underrepresented minorities. Again, the district courts and Fourth Circuit ruled in favor of UNC, holding that the admissions policy using a plus factor as a part of a holistic review was narrowly tailored and again, kind of legally compliant with respect to existing precedent. So what of course is to be determined is what will happen in the current Harvard and UNC cases before the Supreme Court. So oral argument was held in both cases in October of 2022. As Taronda mentioned, Justice Ketanji Brown Jackson has recused herself from the Harvard matter because of her prior service on the Board of Overseers, but will sit for the UNC case. We anticipate that the decision will be published sometime in June. Of course, it's difficult to predict outcomes when it comes to Supreme Court cases, but we know that Chief Justice John Roberts, as well as Justice Clarence Thomas and Justice Samuel Alito, have opposed race-conscious admissions in previous cases. And we don't have sort of prior decisions from Justice Gorsuch or Ketanji Brown Jackson, Kavanaugh, or Justice Amy Coney Barrett. And so while they haven't ruled on race-conscious admissions decisions in the past, we know that it would only take two of the justices to join the others in overturning Grutter and the other precedent and banning sort of race-conscious admissions programs. So the potential outcomes are, to affirm the lower court decisions or to impose narrow restrictions on the prior precedent that Taronda kind of walked through, or to overrule the precedent and impose, clear limitations on race as a factor. So certainly this is a case that's being closely watched by admissions departments, by institutions of higher education. But there are also, a lot of questions about how this might potentially impact employment practices. And it's important to note while this case could potentially be used, depending on how it's written and how the decision comes down, in other matters related to employment practices, there's certainly important legal distinctions about this case, right? It is directly related to college admissions. So it may be used to make arguments about other employment practices, but it's not directly about these employment issues. That being said, issues of relation to employment did come up during oral argument. Justice Kagan did raise the issue about whether employers can consider the benefits of diversity when making hiring decisions. There were also questions about, the impact that a diverse student body has on serving as a pipeline to a diverse workforce. And so there were certainly, some references to employers and employment decisions. We'll see again, how the decision is written. So really, I think the main takeaway, again, institutions of higher education have been grappling with admissions practices throughout the progression of all of this precedent, right? Taking those Supreme Court decisions and revisiting and auditing admissions practices to make sure that they are compliant with the law and what the Supreme Court decisions are saying. I think similarly, right, obviously they'll be doing the same as it relates to this decision. When it comes to voluntary sort of DE&I initiatives, right, at employers, there might also be, a need to sort of review some of those, right, the basis for those, the rationale for those, and kind of compare it to the decision to make sure that institutions or the companies and other entities are still adhering to the law when it relates to some of those diversity, equity, and inclusion initiatives. So with that, I'm going to turn it back over to Eric so we can move on to our next section.
Thanks so much. Really appreciate that, Elizabeth and Taronda. Appreciate you guys connecting the dots there, right? Even though that's a decision in the context of higher ed, I think there are signals that we can take away from that are going to influence how we make decisions, even from an employment standpoint. To round us out today, I am excited to welcome in my colleagues, Sarah George and Betsaida Zudi. I will not take any more time. Let them introduce themselves and talk about some trending and interesting stuff.
Thanks, Eric. Hi, everyone, and thank you so much for joining us today. My name is Betsaida Zodi, and my colleague Sarah George and I will be discussing employment law trends relating to DEI. So today we'll be focusing on DEI legislation that has not received as much national attention. Specifically, we'll provide a brief overview of local, state, and federal efforts that push back against anti-DEI initiatives and address why employers must be aware of growing legislation that promotes inclusive workplaces. So on this slide, we see the many distinct and overlapping employment laws that prohibit discrimination on the basis of certain characteristics such as race, gender, and disability. Despite the wave of anti-DEI legislation and the national attention on these efforts, we continue to see a rise in legislation that promotes an inclusive workplace. Employers must be aware of these recent developments in order to ensure compliance and create a more inclusive workplace. So we'll be focusing on recent changes to Title VII, the ADA, and the FLSA. So here are a couple of examples of emerging employment laws and policies that promote inclusion in the workplace. I just wanted to highlight that although we are categorizing these laws as pro-DEI, most, if not all of these laws build upon current anti-discrimination laws. So quick pivot, I just want to briefly discuss what is at stake for employers here. The most obvious is the cost of defending discrimination claims. The three headlines on the slide are examples of the significant financial consequences that can result from discriminatory practices. While these headlines capture costs that are easy to identify, the indirect costs are arguably even more damaging and difficult to quantify. These include increased turnover, decreased productivity, and reputational harm. Conversely, the impact of a diverse workplace is clear. Studies show that diverse companies, teams, and boards outperform their non-diverse counterparts across various metrics. Diverse companies are 70% more likely to capture new markets and 35% more likely to have financial returns above national industry averages. We also know that diverse organizations are more successful at recruiting and retaining talent, and a diverse workforce increases innovation and productivity. And judges also look more favorably at companies that have a diversity training program. So in addition to compliance efforts, a diverse workforce can give companies a competitive edge, and an inclusive company can create a more productive, innovative, and successful work environment. So this information emphasizes that equity-based approaches to workplace policies are more profitable than a compliance-only approach. Okay, that is the end of my pivot. So recently, there has been a growing effort to prohibit hair discrimination in the workplace. These laws are known as the Crown Act. The Crown Act aims to prohibit discrimination on the basis of hair texture or styles if they are commonly associated with racial and ethnic identity. So employers doing business in any of the states that have passed Crown Acts and employers seeking to create a more inclusive workplace must be sure to understand the legal framework for hair discrimination, train employers and supervisors, and review dress code or appearance policies to ensure compliance. In addition to existing protections for pregnant and nursing workers, there are two recent pregnancy-related acts that employers should be aware of and take proactive steps to ensure compliance. The first is the Pregnant Workers Fairness Act, which creates an express right to reasonable accommodation for a known limitation related to pregnancy. And the second is the Pump Act, which requires employers to provide a reasonable break time to express milk each time the employee has a need to express milk. In addition to state and federal pro-DEI initiatives, the EEOC recently released a draft strategic enforcement plan outlining the 6 subject matter priorities identified on the slide. So why does this matter to you? Well, the EEOC's priorities should also be an employer's priorities. Now that the EEOC has created a roadmap for the types of lawsuits likely to be reviewed by the Commission, employers can and should spend extra time and attention on laws and policies where they know enforcement is growing and take steps to ensure that their employment practices align with these priorities. So while anti-DEI legislation can create a climate that undermines diversity, equity, and inclusion in the workplace, anti-DEI legislation does not fundamentally alter an employer's obligation to comply with anti-discrimination laws. Employers can navigate diversity and inclusion efforts in the face of conflicting state and federal laws by staying informed, seeking legal guidance, and taking practical steps to create a culture of inclusion. So Sarah will now be discussing DEI considerations for technology in the workplace.
Okay, well, I know we just have a couple of minutes here, so I'm not going to keep you longer than is necessary. I just want to highlight 2 specific areas where you may encounter some potential exposure to liability and ways that you can mitigate that risk. So when we're looking at the EEOC's priorities, technology is a large component of that. And within technology, we have artificial intelligence. So part of the reason the EEOC is focusing on this is that increasingly employers are using artificial intelligence in the workplace, everywhere from recruitment to hiring to monitoring employees' progress, and then ultimately in the termination process. So we're getting a little bit of indication that this specific issue is a priority based on a public hearing the EEOC conducted in January of this year. They brought in witnesses from computer scientists to labor advocates to psychologists, and these concepts that were discussed in the abstract are actually showing up in cases now. I don't have time to go into those cases today, but just to give you a sense of what you should be considering, we have a two-step approach here. You need to figure out, where are we using artificial intelligence, if at all? Are we using it in our screening job applications, performance evaluations, or reduction in force determinations? And then how can we mitigate any potential risk of using artificial intelligence? And that can look like regular audits where you're reviewing the software programming, making sure there's no implicit or explicit bias in it, conducting regular legal reviews, and keeping up to date with this changing EEOC guidance and regulation. And we are here to help you do that. Lastly, I want to go briefly into technology in the workplace. Now more than ever, we have a very diverse age group in the workplace, as you can see here from this graph. And as part of that difference in ages, we're seeing differences in communications, differences in lived experiences, and then we're combining that with the fact that the number of lawsuits involving emojis is dramatically skyrocketing. So we're going to put these two things together and look at what is happening. And it really boils down to, we're using different types of communication in the workplace: emojis, emoticons, memes, slangs, and these three emojis alone have very different meanings for a baby boomer or Gen X or Gen Z. If any of you have teenagers, they can help explain what some of these mean to their generation versus what they may mean to you or to other employees in the workplace. So with this, with these multiple interpretations of symbols, memes, etc., there's an increased risk for miscommunication. And so importantly, jumping back to this case study about emojis and lawsuits, employment discrimination is the #2 most common type of lawsuit we're seeing. And so being aware of this for you all, there are a couple of things to consider. This is very general advice. So obviously there may be situations where you need to consult counsel as they arise, but look at ways that we can increase effective communication between all of our employees, regardless of age, gender, ethnicity, and that starts with building a culture of inclusiveness. And then also we have to be proactive and develop strategies to help mitigate risk that stems from miscommunication, especially in light of increased communication in the remote work life age and with increased social media use in the workplace. So developing policies about all of these things, we can help you do that. And we're here for you. So with that, I'm going to turn it back to Eric to wrap us up. Thank you.
Thank you, Betsaida. Thank you, Sarah. I'm sorry that we had to rush through Sarah's presentation, which may have been the most interesting and fun thing that we talked about. As I was listening to her, I think you can, our audience can look out for a blog piece on that at the very least, and maybe another way that we can develop that. I think a lot about that context in the workplace these days, and also maybe because I'm dealing with it at home. I have a 12-year-old who asked me last night what my favorite abbreviation was. I didn't even know how to answer that. Hers apparently is BRB, be right back. But I feel like I needed to learn another language. That is maybe how you sometimes feel in the workplace as well. So thank you, Sarah, for that. Thank you to all of our presenters. Really awesome content. I know that we did a quick overview here, but if I can sum up what we learned today, we are at sort of an inflection point. We've got the Supreme Court case moving through on affirmative action. We have this legislative activity in different states. And it's creating additional obstacles for employers that are interested in working in this DE&I space. But the big picture takeaway, I think, is that there is nothing that we are observing that should prevent an employer who is committed to this from continuing to invest. There are just ways that we can help you do that in a way that minimizes legal exposure. So thank you all for joining us today. As a reminder, this program has been approved for legal education hours, and you can report those using the CEU icon at the bottom of your screen. A certificate of attendance will be emailed to you tomorrow, along with a link that will allow you to view and share a recording of the presentation. And we'd really appreciate it if you could complete the survey that we have, because that helps us ensure that we're giving you the content that you need. So thank you for your time today. We appreciate you, and we look forward to seeing you again soon. Have a great afternoon.
Thanks, everyone.